He's going to talk about marriage equality, where to from here, the impact of the exposure draft as law. He's a lawyer currently an associate professor at the ANU Law School. His areas of interest are comparative law, constitutional law, and international law. Just before Asmi gets up, there was one thing I forgot to say, which is that my understanding of this evening's forum is that we are really going to have a discussion based on the assumption that marriage equality is happening. I think it's inevitable at some point in time, possibly not some point too far away, but I think the momentum is there and it's going to happen one way or another. So the speakers tonight will be talking from that space, from the assumption that it has actually occurred or is likely to occur. So I'd like to introduce Asmi. Thank you.
Good evening, everybody. I'd like to begin by acknowledging that we are on Ngunnawal land, to recognize the elders and their ancestors whose spirits looked after this land and who cared for this land and allow us to stand on their land and discuss matters of mutual interest to us. I'm a Torres Strait Islander, and I was born and raised in Wik country, and that's the language group with which I identify. And I thank the Ngunnawal people for allowing me to live on their land and raise my family on this land. The topic that I have before me is about adapting to marriage equality. And I guess the presumption there is that the exposure draft has become law. But to get to the issue of the exposure draft and the bill that carries that title, one needs to examine how we got to this position in a legal sense, in a legal historical sense. I won't go back to 1788 because that is a horrible year for my ancestors, no doubt. But in that year, we received English law, as happens through the process of colonization, through all colonial powers, but certainly the English on our land. The English brought with them sufficient law to regulate the affairs of each Englishman that accompanied the waves of migration. Non-English people who were invited to settle on this land by the English had to adapt to English law. Three things I think were non-negotiable for the English. That was the use of their language for general intercourse, the use of their law to regulate the affairs of the population as between themselves, and the use of English institutions. English institutions, of course, include Parliament, but here I'm thinking particularly of the institution of marriage. And the definition of marriage largely took, in the early stages anyway, a Judeo-Christian view of what constituted marriage. Aboriginal marriage was not recognized and is still not recognized as marriage in law. So when we talk about equality, we are only talking about really equality as between the immigrant communities and generally excluding my people. The Constitution in the Constitutional Conventions discussed the federation of the colonies into the Federation of Australia, and in order to regulate their affairs, they created a constitution through mutual consultation. And the Constitution provides plenary powers to the states and reserves residual rights for the Commonwealth or the Federation. And Section 51 of the Constitution, particularly Section 51, 21 and 22, are associated with the institution of marriage and reserves this head of power for the federal parliament. However, till 1961, when we have the first Marriage Act, it appears that the institution of marriage was largely regulated, I guess, by the churches, and the registration of these marriages was managed by the states, as it is today. The states and territories do births, marriages, and deaths. However, in 1961, the federal parliament passed the Marriage Act. Most of it is not an issue as far as today's topic is concerned. But the content of what constitutes marriage was largely established by custom. If you were from the Church of England, I guess it had a particular view. If you were of the Jewish community, it had a particular view. And if you were, say, a Protestant of another type, it had a particular view. And if you were a Catholic, then it had a particular view. And for Catholics, I guess the issue of divorce was not permitted, so there was a very particular view of marriage there. And Protestants probably had a different view. However, the Act in 1961 did not define the parties to a marriage. And it was assumed that it would be a heterosexual, this heteronormativity that exists in our society to, be a marriage between two people, a man and a woman, to the exclusion of all others, I guess, because polygamy and polyandry were not accepted, so you can clearly see the distinction between, say, Aboriginal marriage laws and white marriage laws. However, that was unsaid. In 2004, this issue was clarified, and the 2004 Amendment Act, which amended the Marriage Act, defined marriage as a partnership between a man and a woman to the exclusion of all others for the duration of their natural lives. And this was further clarified by saying that marriage that had occurred in another foreign jurisdiction, or jurisdictions outside Australia, between, say, two people of the same gender, was not recognized as marriage in Australia. So there was a very clear exclusion of people who belonged to this particular category. Of course, there are issues of multiple marriages and all of these kinds of issues as well, which are also excluded. So the definition of marriage, while it is customary and it has content which comes from the communities from which they were drawn, was nonetheless circumscribed by the practice, and also then Parliament saw fit to entrench this into a legal format where the possibility of two people of the same gender being in a marriage relationship could not occur. Of course, there were other instruments that were created to allow marriage-like relationships. The de facto relationship legislation that permitted a man and a woman, or a man and many women, or a woman and many men to cohabit in a particular marriage-like arrangement was permitted under that act, or those acts. Sorry. But the content of what constitutes a marriage is more than the cohabitation of men and women, or women and men, or whatever permutation you might seek to express. But the idea, if we take a perspective from a rights perspective, then clearly a marriage-like relationship does not bring to bear the same legal presumption as does a marriage. So, for example, if you are married, in the meaning of the Marriage Act, all previous wills are set to naught. You need to redo your will. The laws of succession apply to create certain legal presumptions as to who shall take in the event of the death, in the state death. There are issues of evidence that are not required to establish ownership of property, the ownership of the residential rights of children. There are a whole lot of presumptions that go with marriage. So if we talk about creating equality through other legislation, then I think we probably are not doing justice to people who seek to celebrate their love for each other in an institution that has been recognized in their culture for so long. So this is an issue of maybe people of Judeo-Christian background who have valued marriage as an institution and who seek to have that same kind of relationship between any two people. But beyond that, to have the rights and obligations that go with the institution applied to them as a matter of fact and as a matter of law. So if we go to 2017 and we say that, because we are adapting to the marriage equality, we look at the issue of same-sex marriage and how our society would regulate it. A lot of opposition from the exposure draft that came in, and I urge you to have a read of it if you have the time to do so. It carries very strong, passionate arguments on both sides, and you can understand that this is a very emotive issue for many people. But the main contention here was that that we need to do this because we need to be in conformity with our international obligations, and our international obligations would, in the view of some, require us to create equality of marriage for people of the same sex. But that view was not accepted by the majority of the Senate in the exposure draft, and it said that the meaning of marriage in the covenant, the International Covenant of Civil and ICCPR for short, was not the same as creating a legal right to marriage. And there is some argument on both sides of that particular view. The rights and obligations of celebrants is taken into account in the exposure draft. So if you belong to a particular religious confession, and just because everybody has disclosed their religious confession, I would like, sorry, I should have said this at the start, that my religious confession is Muslim, and I have very particular views that might or might not accord with that faith community, but as everybody else has disclosed that, I'm sorry, I should have done that at the start. So with the issue of religious celebrants, the bill or the act, as we would call it for the purposes of tonight's discussion, allows people of a particular faith to not perform celebrations according to between a man and a man and a woman and a woman. So there is no compulsion that they do that. The question whether civil celebrants would be allowed to not celebrate the marriage was also an issue. And in drafting the exposure draft, there were some polling done, I think, and they found that only 3% of celebrants said that they would have an objection to an equal, marriage between the same gender. But the exposure draft permits these people to not celebrate a marriage. There were other issues about services that attach to marriages, like weddings and reception halls, would people be able to refuse service? And it seems like, yes, you could do that on that basis, and that was challenged. And people from the Law Society said that this was the most dangerous exception that was permitted in that draft. It's a very difficult issue for many people, but I think the issue is about love, if love is a part of marriage. I mean, we can look at marriage as purely a legal contract between two parties, and in that case, it would be no different to a contract for the purchase of a product or the sale of goods or services. However, marriage, notwithstanding that it's a contract, encompasses something more than a mere transactional issue between people. And it includes this issue of love and affection between two people. And the question is, should the state seek to regulate who can love whom and who can live with whom? And not only that, should the state be allowed to create legal presumptions for one group of people that don't exist in the other group of people? We don't have legal equality in Australia. I mean, it is very clear that, Section 51(26) of the Constitution allows the Parliament to make laws, differential laws for different people. However, as many Aboriginal people are seeking to be treated as equals in this country, perhaps it would be disingenuous for me to ask for that right for myself while denying it to other people. So I would like to conclude by saying that the exposure draft seems to create a reasonable compromise. I mean, I don't know what's reasonable, but most people seem to think that you give a little bit, you take a little bit, but not oppress a whole group of people through the institution or through the legal rights and obligations that attach to that institution. Thank you very much for your time, and I'm happy to answer any questions that you may have on the law. Thank you.
Thank you, Asmi. That, for me, has certainly, I guess, raised some questions, which perhaps I'll reserve until the question and answer